Okay, so ang topic for this video is the definition of criminal procedure. Ang kailangan nyo lang naman tandaan sa criminal procedure is method or procedure. Sinabi kasi natin procedure, Tagalog, proseso. Ganon din sa method. Sinabing method, there are systematic procedures. No? Step by step. Hindi pa pwedeng magpunta kagad tayo sa step 3 nang hindi tayo dumadaan sa step 1. Yun po yung sinasabi ng criminal procedure. Or in other notes, ito yung nilalagay nila, adjudication process. Pag sinabing adjudication, that refers to paghusga. Okay. So for example, si A, sinaksak si B. What is the crime committed? So i-check natin yung criminal. Stabbing incident, namatay, anong crime na nakomit? Possible homicide. Can we convict already A for the crime of homicide? The correct answer for that is no. Because there is a method in which we need to follow in order to apprehend, prosecute, and punish a person in case of his conviction. Hindi porke sinaksak yan, nakita mo, ura-urada, convicted na kagad siya. There must be due process. So that is the purpose why there is a criminal procedure. Now, dahil nabanggit natin yung criminal law, how do we distinguish criminal law to criminal procedure? Pag sinabi natin criminal law, it is under our substantive law. And when it comes to criminal procedure, that refers to remedial or procedural law. Ano ba ibig sabihin ng substantive law? Pag sinabi natin substantive law, it is that part of the law which creates, defines, and regulates rights of a person. Medyo mahaba, no? Paiksain natin. Pag sinabing substantive law, it defines the law. Sinasabi niya kung ano yung batas. How about remedial or procedural law? Ito na yung dinidiscuss natin sa criminal procedure. It provides for a process, for a method. So meaning to say, pag sinabi nating criminal law, it answers the question, what? And then when it comes to criminal procedure, it answers the question, how? Criminal law, ano ba yung crime na nakomit? Criminal procedure, paano? Paano natin siya mapapakundik? Paano natin mapapakulong? So that is the simplest way on how to distinguish criminal law to criminal procedure. In the given example, si A, sinaksak si B, gladly, nabuhay si B. Pero, he incurred serious physical injury. Hindi na aresto si A. Question. Habang buhay na lang bang makakalaya si A sa crime na nakomit niya? The answer for that is no. But another question, can we arrest A immediately for the commission of the crime? Let's add some facts. Paano kung lumipas na yung ilang araw, hindi pa naaresto si A? Dahil nag-iisip pa yung pamilya ni B, kung ipakukulong ba nila si A or hindi. Then later on, napag-isip nila, kailangan pala talagang ipagtanggol ang karapatan ng kanilang kamag-anak na si B. Question now, can they immediately arrest A for the crime of serious physical injury? In that case, the answer for that is no. Why? Because that is not in accordance with the criminal procedure. Although it is defined by the criminal law, sinabi kapag sinaksak, nasugatan, serious physical injury, but that is not the proper process on how to arrest a person. Di ba makikita nyo yun sa Rule 113? Arrest, rule on arrest. So dahil wala naman doon sa binabanggit na warrantless arrest, ang ating senaryong binibigay ngayon, then definitely we cannot validly arrest A for that crime. So anong remedy, sir? Kung wala na pong paraan, kung hindi na natin ma-arresto si A, ano pa pong ibang paraan? Meron pa po ba? Meron pa. And that is under your rules of criminal procedure from Rule 110 to Rule 127. Ano ba yung sinasabi ng Rule 110? Rule 110 speaks of your prosecution of criminal action. So meaning to say, kung hindi mo na-aresto, hindi nakulong si A, gusto mong ipakulong, sampahan mo ng demanda. So dyan mo makikita yan sa Rule 110. Eh sir, tanong mo, no? Paano naman po yung mga ginastos ko sa pagpapagamot, sa mga gamot, at saka sa hospital bills, at saka yung abogado na babayaran ko pag sinampahan ko siya ng kaso? Okay? Ano naman po ang remedy natin para dyan? Doon mo makikita yan sa Rule 111 or the prosecution of civil action or the institution of civil action. Now, after that, what will happen? For example, si Mr. Police Officer ay nag-provide ng iyong criminal complaint. Siya yung tumulong, nag-assist sa'yo in order for you to file a criminal complaint. What will happen now? The next step is preliminary investigation, which can be found in Rule 112. Diyan sa preliminary investigation, kailangan natin tandaan na ang inaalam sa preliminary investigation is not conviction, but rather mere probable cause. May basihan ba para mag-file ng demanda? Yan po ang sinasabi sa preliminary investigation. Now, if there is a finding by the prosecutor that there is a probable cause, then definitely he will now file or he will now make his resolution and submit it to court because there is a probable cause, existence of probable cause. What will happen now? Sabi mo, maa-aresto na ba natin kagad si A dahil meron ng resolution ng prosecutor at meron itong probable cause? Pwede na ba natin pa-aresto si A? The answer for that is not yet, because it is only the judge who can order for his arrest by virtue of warrant of arrest, which can be found in Rule 113. Kung kanina si prosecutor nag-conduct ng preliminary examination, this time si judge magkakandak ng preliminary examination. Ulitin ko, kung kanina si prosecutor nag-conduct ng preliminary investigation, this time si judge magkakandak naman ng kanyang preliminary examination. So kaninong trabaho po ang preliminary investigation? Kay prosecutor. Kaninong trabaho ang preliminary examination? Sa judge. Anong purpose ng preliminary investigation? To determine whether there is a probable cause for the filing of a complaint. Anong purpose ng preliminary examination? To determine whether there is a good ground for the issuance of warrant of arrest. So that is the difference between the two. Now, kung sakaling nag-issue na ng warrant of arrest si judge, inutusan na niya ang public officer, ang police officer na arrestuhin si A, what will happen now? Makukulong na lang bang habang buhay si A sa loob ng custodial facilities? The answer for that is no. Meron pa siyang remedyo, meron pang remedy, meron pang paraan para magkaroon siya ng pansamantalang laya. And that is under your Rule 114, which is bail. Pag sinabing bail, magpapiyansa daw siya. So kung sakaling nakapagpiyansa siya, kailangan din niya malaman yung mga karapatan niya bilang akusado. And that is under your Rule 115. May keyword ako dyan, pip text in order for you to have keyword, no, in memorizing those rights of accused. Then later on, after knowing his rights, what will happen now? Of course, there will be arraignment, which is under your Rule 116. Ano ba yung sinasabi ng Rule 116? Arraignment and plea. Ano ba pinagkaiba niyan, sir? Ano ba ibig sabihin niyan? Pag sinabi nating arraignment, that is the reading of the cause of accusation against a person. In Tagalog, binasahan daw siya ng sinasampang kaso sa kanya. So si A, for example, binasahan siya. Ikaw, A, ay nasasakdal sa kasong serious physical injury. That is arraignment. Tatanungin siya, totoo bang ginawa mo ito? Sasagot si A, hindi po. That answer is what we call as plea. So yung arraignment, binasahan ka, yung plea, sinagot mo. Is that clear? So that is the difference between arraignment and plea. Now, after receiving the complaint, nakita ni A, ni accused. Sabi ni A, aba, teka, parang mali yata itong sinasampang kaso sa akin. Or maaaring walang karapatan yung public officer para mag-file ng demanda niya or other grounds na sa palagay niya meron siyang karapatan para ipa-dismiss kagad yung kaso niya by mere reading of the complaint. Now, question, kailangan pa ba magkaroon ng judgment? Kailangan pa ba mag-undergo ng trial para lang mapatunayan na dapat i-dismiss yung kaso niya? The answer for that is no. Because there is another remedy provided by Rule 117 or motion to quash, wherein upon receipt of the complaint, A can immediately move for the dismissal of the case. Pwede niya na pa-dismiss yan. Okay? So alamin po natin yung mga grounds na yan pag nasa Rule 117 na tayo. Pero may keyword po ako dyan. And that is OJAP ni JD. For the meantime, wag po muna natin discuss yan. And doon na lang yan pagdating natin sa Rule 117. Now, if ever walang grounds for motion to quash or kung sakaling nag-file ng motion to quash but later on it was dismissed or not granted by the court, what will happen now? Of course, there will be trial. But before trial, let us first discuss Rule 118, which is pre-trial. Kaya nga pre-trial kasi bago mag-Rule 119, which is trial, meron munang Rule 118, which is pre-trial. Meaning to say, bago magkaroon ng trial, meron munang pre-trial. And that is under your Rule 118. What is the purpose of pre-trial? To expedite. In Tagalog, papabilisin. Para pagdating mo sa trial, hindi na tatagal. Yung mga bagay-bagay na pwede nang isettle sa Rule 118, isi-settle na po din. Like ng stipulation of facts. Yung mga bagay na hindi naman na kailangan pa mag-present ng ebidensya, pwede na pong aminin yan dun pa lang sa pre-trial. So marami pa po yan. Pero saka na lang po pag nasa Rule 118 na tayo. Let us now proceed to trial. After pre-trial, there will be trial. Dito sa trial, under Rule 119, malalaman natin kung ilang days ba ang trial. Kailan ba magko-commence ang trial? Commence, pag sabing commence, magsisimula. And then later on, ilang days ang ibibigay sa iyo ng court para mag-prepare for trial. Yan ay lahat. Ay alamin natin pag nasa Rule 119 na tayo. Then later on, after trial, what will happen? Of course, there will be judgment, which is under your Rule 120. Okay? So, once there is a judgment, it may be judgment of conviction or judgment of acquittal. For example, si A na-convict, may paraan pa po ba siya? The answer for that is yes. Meron pa. Kaya nga po criminal procedure remedial law merong remedyo. So, kung sakaling na-convict siya, hindi pa yan automatic convicted na kagad siya. Hindi automatic na kailangan niya nang i-serve yung sentence niya. Dahil meron pang paraan, proseso, method, para ma-reverse yung decision against sa kanya. So ano pong paraan yun? That is under your Rule 121, Rule 122, which is 121, motion for new trial or reconsideration. Rule 122 is appeal. So, aapila ka. Okay? On the part of the complainant. Kung na-dismiss yung complaint. Ano yun? Thank you na lang ba yung ginawa ni A sa kanya? The answer for that is no. Because there is another remedy. Pwede niya pang i-refile yan provided it will not tantamount to double jeopardy. Uy, double jeopardy raw. Aalamin natin yan pag nasa motion to quash tayo, Rule 117. But for the meantime, dinidiscuss ko lang sa inyo ang process under your criminal procedure. Then later on, let's skip Rule 123, 24, 25 because those are the rules being conducted or being followed in the NTC, RTC, Court of Appeal, Supreme Court. So for board purposes, hindi siya ganong itatouch, no? Hindi ganong natatouch. So let us proceed to the more important discussion or topic, which is under your Rule 126. Ano naman yung sinasabi rito? And that is your search and seizure. Okay? Dito malalaman natin yung search warrant. Kung ilang days ba dapat i-execute yan? Yung lifespan ng search warrant. Ano ba yung mga proper way on how to serve search warrant? Nasa Rule 126 yan. At mga instances na kung kailan tayo pwedeng mag-search although wala tayong search warrant. Ibig sabihin, exception to the search warrant. Now, after Rule 126, meron po tayong Rule 127 o yung provisional remedies natin in criminal cases. Okay? So, yan po ang mga i-discuss natin. Before going to the next slide, let me clarify that there are three branches of the government. Those are, number 1, legislative. Number 2, executive. Number 3, judiciary. When we say legislative, it is the branch was the power to create law. Sila raw yung gumagawa ng batas. Sino yung mga yan? Congress, Senator. How about the second one? Executive. It is the branch which executes the law. Sila raw yung nagpapatupad ng batas. Kasama na po ang ating Presidente, DILG, and under DILG, alam niyo naman po yan, kapulisan, or other law enforcement agency. Kaya nga ang tawag sa atin, law enforcer. Kasi ini-enforce natin yung law. Is that clear? Yes, sir. Now, the third one is judiciary. What is the power of judiciary? To interpret the law. Meaning to say, there is a law, and that law was implemented. However, there is a question in the law or in the implementation of the law. Who will decide for that question or for that issue? It is the judiciary. Si judiciary po ang magdi-decide kung ano ba yung dapat na ibig sabihin ng batas na yan. Ano ba yung dapat na in-implement ng mga executors natin? Clear? Yes, sir. Again, what is the power? Who has the power to create laws? Legislative. What's the power to execute the law? Executive. What's the power to interpret the law? Judiciary. Question. Can the judiciary create laws? The answer for that is no. Why? Because it is the Congress or the legislative which is granted to create laws and not judiciary. Is that clear? Yes, sir. So with that, let us proceed to the next slide. Who creates rules on criminal procedure? Sino ba gumawa ng mga rules on criminal procedure? Yung diniscuss ko sa inyo na Rule 110 to Rule 127. Okay? Some of my students will answer, Sir, it is the legislative. So meaning to say, Congress daw ang gumagawa ng rules on criminal procedure. The answer for that is no. Okay? It is the Supreme Court. So if you're going to ask, can we consider rules on criminal procedure a law? The answer for that is no. Because it is not created by the Congress, but it is created by the judiciary or by the Supreme Court. So definitely it is not a law, but it is just, or it is a rule. But please take note that once the Supreme Court interpreted the law, that interpretation has a force and effect of law. So, in Tagalog, kahit walang karapatan o kapangyarihan or authority ang ating Supreme Court na gumawa ng batas. Kasi nga, Congress ang may power na gumawa ng batas. Pero once na mag-interpret ang ating Supreme Court, okay, mag-interpret ng batas, that interpretation has force in effect of the law. Meaning to say, parang batas na rin yung interpretation niya at kailangan nating sundin. Is that clear? Yes. So with that, okay, thank you very much for your listening.